Hello, good evening. It's August, is it 4th of August today? And everybody's here, so it's a full house for the live stream. And what we were just deciding we were going to have our theme for the evening is Section 204A appeals, which is a subject that's probably only very interesting to people who are interested in homelessness law. It's difficult to give it much wider application. But before we start that, Mike, you mentioned an issue you wanted to talk about, which I can bring up a case on in a minute, but I thought let's dive in with that first.
Yeah, cool. Thanks, Will. Yeah, okay. Situation is, someone I worked with for a long time, owed the main duty, gets an offer, which is kind of written in a letter, which basically says final part six offer, and it's a template which says, this property over here is, we consider it to be suitable. There's no meaningful engagement with the Equality Act whatsoever. So there's the template paragraph where I've carefully considered whether the Equality Act is, kind of in play here or whatever, or that's nonsense they said. But they don't identify this person's disabilities or anything like that, or even kind of start even to consider it really. So I emailed a council, like head of service, because I'm like, this person's been through a ridiculous amount of, just rubbish basically. And I said, look, this isn't, I can't refuse for anyway, but can I speak to someone sensible? Can someone sensible can have a look at this case and just kind of actually speak to the client to work out what might be suitable, because there's been no conversation for years. So then I get an email from a housing officer basically saying, oh, now that you've refused the property. And I'm like, well, no, that's not what I said. So I guess I'm just interested to know what do you have to say, or what do you have to do to refuse a property? As I say, it wasn't for me. I specifically didn't. I worded it so that it wasn't kind of refusing the property. It was just saying someone needs to kind of actually have a sensible conversation here, because I say it'll be dead easy to challenge. But I just rather not have the client go through all the stress of kind of having to wait for it all to happen. Just rather someone sensible looked at it and said, oh yeah, no, it's pretty stupid actually. We shouldn't have done it. So yeah, that's my question.
Well, does anyone want to have a go at answering that one before I have a go? Uh, Now's your chance. Um, okay, well, I'll tell you what I think. Um, and it's coincidence because I was looking at this very subject today in connection with one of my own cases. And it's involved a case where a client had said, I mean, I'd done my usual mantra, do not refuse the offer, accept it and request a review. Um, Except it was 188 accommodation, so that was a bit inaccurate. I said accept it and challenge it, basically. So she did, but then she was given what I think was a very unreasonable deadline of, so you've got until 4 o'clock to come and collect the keys, or we'll treat that as a refusal. And the this went on for a few days, and she still hadn't come and collected the keys. So they said, right, we're treating that as a refusal. And as is often the case with this type of thing, the housing officer managed to write a really long discharge of duty letter saying why they were going to treat their interim duty as discharged. And they said they were treating the refusal to, well, they were treating the failure to collect the keys as a refusal. And they referred to a case in that, which is this one here. I don't know if you can, I'll change to the screen here, which if you want to find out more about this case, you can do it by accessing the case law database, which is a link to on here, and look for this name. There's a bit where you can search by name, and you'll find Nicola, I'm not sure how to say it correctly, Nikolaiva versus London Redbridge. And in that case, I haven't actually got, I mean, the Court of Appeal judgment is on here for those of you who want to read it in detail. And I think it's quite an old case, 2020, and it's before Jan Luber in the court. Oh, it's an appeal from Jan Luber to the Court of Appeal. And I haven't read it, but looking at the summary that I put in the note, and I think I may have stolen that from Nearly Legal. Hang on, let's just see. I'll go back to that. I'm not sure, but yeah, what's happened? I think the answer to your question, Mike, is that, or if the question is when can they treat you as refusing it when you're saying you're not refusing it, and then more specifically, does that apply to your case? I think the answer is if you do if you do something which is completely incompatible with you accepting something, despite you saying that you are accepting it, then you're not. Then I think they're entitled to treat you as having refused it. So, for instance, in Nikolaeva, I think the applicant was refusing to sign the tenancy agreement for the new property, which isn't the same as refusing the offer. Because if they say we're offering you this and you say no, I don't want it, that's a refusal. But you could say yes, I'm accepting the offer, but no, I'm not going to sign the tenancy agreement. And I think that there comes a point where if you're refusing to sign the tenancy agreement, you're effectively refusing the offer. Would you agree with that? I mean,
I don't know exactly. I mean, that seems to make more sense and is also reassuring for me because I think nothing's happened that would be incompatible with them
yeah, but
accepting
it
the offer.
shows
I
you
think
you've
just
got
keep
to go
going.
quite a long way to actively do something. If you said I'm accepting it, but don't ever expect me to move in there, um, that would possibly be I mean, almost certainly be a refusal, or they'd be entitled to treat it as a refusal. Because remember, with these challenges, you're not asking the judge to substitute their opinion. You're sort of saying, was the council's decision so unreasonable that no reasonable person could make it? Uh, and so I think that in your case, though, where all you did was express reservations about the offer, which is perfectly compatible with accepting it, that's outrageous to treat it as a refusal. And then the issues you raised about the Equality Act and so forth would tend to be, I think, would be arguments about the suitability itself, unless the issue of the disability impeded their ability to communicate. You see what I mean? Because I've had that before. You've got, if you've got sort of 8 hours to accept an offer and you're suffering from depression and anxiety, somebody may have a panic attack and not respond.
And
So
I think in this case, like this person has had like there's been a history which the council would be aware of that when there's been a mention of a change of address, there's been a really like negative, anxious reaction to it, and it's taken some kind of just reasonableness really and kind of just some support to help them just kind of get their head around it and just kind of and actually in this two cases, so two situations have been fine, but it's that kind of like lack of. It's just that kind of classic kind of council lack of any conversation, sending a letter saying if you don't accept this, we're going to end all duty. Just kind of like, yeah. Sorry, Shannon, I was seeing you coming in.
Oh no, I was just gonna say, like, going off on what Will was saying about the reasonable sort of presumption from the council, it'd be more reasonable for them to assume that you are making a like Section 202 review. But also 15.48 of the Code of Guidance says around they should allow applicants a reasonable period for considering offers and that there's no set time. This might require longer than others depending on their circumstances. So what you've just said about extreme anxiety when given other move addresses, and whether they want to seek advice, like talking to yourself, talking to a housing officer about the suitability, they're literally asking for advice. They're literally, in my mind, they're doing 15.48, which means they're not rejecting it. Yeah.
Yeah.
just
Yeah.
get that on screen.
I'm hoping that someone with some brains would look at it basically rather
But
than like.
the funny thing is, though, and this is the sort of Kafkaesque sort of nature of, or maybe Orwell is better, that so I mixed the approach of the council. Because if you said to the council, please can you treat my comment, so let's say you unfortunately fail to formally request a review within 21 days, then you wrote to them and said, look, I know I forgot to ask for a review, but I did write to you saying we weren't happy about it. Could you treat that as a request for a review? You can almost bet that they'll say, no, no. That wasn't a request. You did not request a Section 202 review. You just made negative comments. Whereas they'll refuse to take any sort of wider interpretation of your comments. But they'll jump on the opportunity to expand on the comments if it means they can treat it as a refusal. Which I don't know is pretty depressing, isn't it? That it's that predictable. So, but the good thing is, I think you're onto a good thing there. I think that's a strong challenge. Unfortunately, in my one, I had the situation where the client had applied. They made her the offer during the relief duty, and so they treated their 188 duty as discharged. And I said to them, this could be a fascinating fight we could have over this, but the relief duty expires in 3 days. So you're either going to find that you don't owe her a duty, or you're going to have to consider an offer under Section 193 if you do accept a duty. I had a case involving Waltham Forest, and I think it's them that's wrong, not me. But the client had refused an offer of 188 accommodation, and they've left him in the accommodation where he was, which is unsuitable. And then they've accepted a 193 duty. So I sent them a pre-action letter, I think, saying, well, you've accepted a 193 duty, but he's still in the accommodation he was in before he applied to you. What are you going to do? And they said, why don't you request a Section 202 review? And I said, well, I don't think I can do that because you haven't given him this accommodation. So I'll let you know, more to follow on that one. So let's go back to homelessness appeals, or more particularly Section 204A appeals. For those of you not familiar with the jargon, Section 204 is an appeal against a refusal by a council in relation to how it discharged its duty to a homeless person, which has been upheld on review, or the council have failed to carry out a review. Section 204A is an appeal against a refusal to provide the appellant with accommodation pending the outcome of the main Section 204 appeal. God, I'm almost boring myself senseless by just saying that, because it just sounds such a load of lawyer talk, doesn't it? But forgive me if it does. Does it sound really dry? But
Yep.
if I haven't
I
lost
guess
you,
it's unavoidable, isn't it, really?
yeah. See, common sense would say that if you've got an appeal and you put it into court, the judge should, everyone would say, okay, well, they're appealing, let's give them the benefit of the doubt and give them somewhere to stay, unless the appeal is completely ridiculous. But no, it's not that way. So the first problem you have is that you're not just saying, please, can I have accommodation pending the outcome of the review, it's with the appeal, which is sort of what you'd be saying in a judicial review, because you don't have to go. But in a Section 204A, you're actually having to go through the motions of this appeal that they've made an error of law in refusing you accommodation, which makes it slightly crazier, because that means you've got to put all your arguments through the sort of prism of an error of law. Although, to some extent, an error of law at the end of the day is, you can make an error of law out of an error quite easily, but that's another story. So if we look at these cases, the reason that we're sort of interested in this subject tonight particularly, or Karis suggested this, so I think the interest, Karis, if I'm right, is that you'd seen this case that was reported on Nearly Legal over the weekend, which is called PB versus the Royal Borough of Kensington and Chelsea,
Yeah.
which unfortunately is, the link doesn't work that I put there. It should do. So I'll go back to, I'll repair the link. I think it's there. Yeah, here it is. Yes. So Nearly Legal has done a long article about this case, which is good because it's a county court case. So unfortunately, there isn't a law report of it available anywhere. So we've only got Council's unapproved note of the judgment, and we won't be able to see the actual judgment itself.
What's the difference between the actual judgment and this? Because I didn't realise there was a difference.
Yeah. Well, the judgment is the judgment is what the judge says ultimately, yeah. And the judge can give the judgment in two ways. One is they can hand down a written judgment, or he or she can give what is known as an again more lawyer jargon ex tempore, which means basically a spoken judgment. At the end of the hearing, the judge will say, "Well, I've heard enough. I've made my mind up. Here's what I say," and that's you've got to be quite confident to be a judge to do that, because somebody might be wanting to appeal you, and you get appealed enough times and somebody comes and taps you on the shoulder and says, excuse me, you're causing us a bit of headaches at the appeal level because all your decisions are getting successfully appealed. So many judges prefer to go away and have a think about it and hand down a written judgment, right? So a written judgment is something you can actually sort of get your teeth into. The problem is if it's only a spoken judgment, the judge isn't obliged to provide a written version of it. You could apply for a transcript of the judgment. So what you then have to do is get a recording. You have to apply to the court for a recording, and then the recording gets sent to a transcript provider, and then they produce a transcript and send it to the judge for approval. And that's why they've used the term unapproved here, because this hasn't been what's said here hasn't been approved. So the judge may, it's unlikely the judge may say, I never said that, but the danger is that some people might want to twist what the judge said so that it means what they want it to mean. But here I think we can take it that although it's unapproved, and the problem with it being an unapproved, we can't sort of go quote, sending chunks of it because it's only this barrister. And by the way, the barrister on this case is Miranda Grell. I don't know if you've heard of Miranda Grell, but if she's listening to this, I'd like to say hello and congratulations, because she, for a long, long time, was working at Hackney Law Centre. I think it was Hackney Law Centre, forgive me if I'm wrong, and was very active in social media and promoting there. And I'm not sure how long ago it was, probably years and years ago. And I'm sorry, Miranda, if I'm suggesting you're only newly qualified, but she's now a full-blown barrister. So congratulations on that. She's got, she's a very good barrister because she's got this really good decision, which I shall go back to talking about now. So what's happened in this case, and you may think this shouldn't be such a big shock horror, is the judge has actually ordered the council to give the person temporary accommodation pending the outcome of the appeal. Which you think, well, that should happen fairly routinely. But no, this is very unusual because there's a history. And this is where the nature of it being an appeal on an error of law becomes particularly frustrating. That if you go back to, well, to start with, the courts, in the case of Mohammed, which was almost immediately after the 1996 Act came into force, which introduced Section 202 reviews and Section 204A, Section 204 appeals. There weren't any before that. It was just judicial review. And one of the driving forces behind this was that the High Court was so fed up with homelessness, because like literally these High Court judges were spending their whole time deciding issues about whether somebody could manage 3 stairs in a temporary accommodation, and they would say, well, we didn't train all these years to do this sort of stuff. So they then said, well, let's farm it out to the county court, and let's also make it a bit difficult for people to actually sort of make judges listen to arguments about steps and things. Let's make it about an error of law. And so the first time this came up in a big case was in Mohammed. There was another one called Nasion at the same time, I remember, but they were both rather negative cases. And they were about refusing people interim relief, so you wouldn't get an order like the one in this case. And one of the ridiculous things that was said shows how out of touch the judges are. I mean, in Nassion or Mohammed, they said there's no need for interim accommodation because the court will deal with the main appeal so quickly that they won't be homeless. Unfortunately, that's not true, and it takes about 6 months. Well, no, 4 to 6 months average now. But I would say no, I would say six. Let's call it six. Between sending off the appeal and getting a hearing, you're looking at 6 months. So that was the sort of reflection of the level of reality. But then Mohammed said there was 3 tests you had to satisfy to get temporary accommodation. You had to show that you had a good, strong appeal on the main appeal, but that wasn't enough. You couldn't just come to court and say, I've got a really good prospect of success of being found to be entitled to be housed, so please house me while I'm waiting for that, which you'd think, well, maybe that's a reasonable request. But no, you had to give new information, which the council didn't have before, which was a problem, because if you'd done a thorough job at the 204 stage, you might not have very much. Although you can usually find some new information, sort of a letter from the doctor or something. And then the personal circumstances of the appellant, which would have to show that this person would suffer particular harm if they became homeless. If it was an appeal against a vulnerability decision, you might say, well, this whole case is about somebody suffering greater harm if they became homeless, so surely you should give them the benefit of the doubt. But no, it had to be that you'd have to show that you had personal circumstances that meant things would be seriously bad if you didn't get housed while the appeal was going on. And that might you'd need to show disabilities or suicidal ideation, that sort of level of problem. And well, I mean, there's been a history of cases over the years where people didn't manage to meet those tests. Fortunately, I must say, a lot of local authorities are pretty humane. I know I slag local authorities off a lot, but they usually will agree to accommodate pending appeal. In my experience, I don't have to have these fights, but sometimes you get the odd one. I'll come on at the end to say that this really only affects single people with no children who haven't got obvious care needs, but I'll come back to that. So to make things even more ridiculous, if you can get over the Mohammed obstacles, so you can say, yes, I've got a strong appeal. Yes, here's some new information, genuine new information. I've been prescribed with this stronger medication based on concern about my condition. And also, here's a letter from my doctor saying they're very worried about me deteriorating further if I'm on the street. You get all that, and the judge can actually find in your favour and say, yes, I think that I will allow this appeal against the refusal to provide accommodation pending the main appeal. You think, oh, great, they're going to get accommodation now. No, they're not, because that's just a finding that the decision was wrong. So he can say, go away and make another decision. And so you're still homeless while they do that. And in this case here of, where was it? Oh, it's on my, is this the nearly legal one? Sorry, I'll just go back because on the blog, yeah, is it this one? Oh, yeah, whoops, sorry, let's just go to here, I'll show you. There was this case that I've mentioned, Quadia. Yeah, this is a tragic case from 2012 where they said, yes, the appeal is okay. Yeah, we think that the decision not to accommodate pending the appeal was wrong, but we're not going to allow it because in order for you to succeed and for us to make a mandatory order requiring the council to house you, we have to be persuaded that it would have a seriously prejudicial effect on your ability to pursue the appeal. So the argument was, well, if you're street homeless, you may find it more difficult to pursue the appeal. But in Quadia, they said, no, not really, because and this is true in the sense that the point they made, but I don't think it's a fair justification. They said, well, actually, a homelessness appeal requires very little input from a client. It's all lawyer driven because the lawyer prepares a grounds of appeal and a skeleton and a bundle, and the judge considers it. There's not really much input from the client that being homeless would prevent you from providing. So, believe it or not, they said it didn't amount to substantial prejudice, and so the person was able to remain homeless, despite having satisfied a judge that the decision to refuse accommodation was unlawful. And this was there's an article from Duncan Lewis here. Yeah, that one, that link worked. So this is one from last November, where they said the court had done the same thing in their case. It's good news that the judge said yes, the refusal to accommodate was unlawful, but bad news, I'm not going to order them to give you accommodation because it's open to them to go away and think about it again and make another negative decision. So that's why PB is some good news, because in PB, the judge did actually go the extra mile and make a mandatory order. And you may think, well, what was so special about PB's circumstances? And I mean, perhaps it's just that things are progressing a bit and that judges are being more sensible. But the condition that PB had was particularly bad. And let's say the reasons given by the council for ignoring those things was particularly bad. They were relying on a housing needs assessment that was 3 years out of date. And they made the sort of stupid comment that I'm afraid reviewing officers sort of must regret afterwards. But they get into a sort of, I think they sort of think they're Louis the 16th or something, and they're making these sort of imperial decisions and comments. But believe it or not, the PB had a do you pronounce it sleep apnea? How do you say that thing where you need to put a
Sleep
thing on your how do you say it again?
Apnea.
Apnea. Oh, it wasn't that difficult. Sorry. Sleep apnea. So she had a machine that she'd been prescribed to wear at night. And she had the good argument to address that last bit about your circumstances and how you would suffer prejudice. They said, not prejudice to her right to do the appeal, but she said, I need to have electrical plug. I need to basically have plugs to plug my machine in at night. If I'm homeless, I can't do that. So the reviewing officer seriously said, well, you could go to a library and charge it during the daytime. I suspect with no inquiry, no library saying, yeah, come on down, everybody charge your machines in our library. And they also said you could ask the hospital for portable batteries for the machine. And I think the judge was particularly unimpressed by that sort of nonsense. I mean, I'm assuming that there wasn't a library putting in a statement saying, yeah, we welcome people charging their electrical machines. And so the judge made the comment, or is quoted here as making the comment that, are you all still there? Sorry, one of my screens has gone out. The judge made the comment that he wasn't impressed with the way in which they dealt with all that. The interesting thing is, and I'll have to look into this a bit more, what I haven't checked is the extent to which that issue about prejudicing your ability to pursue the appeal was dealt with. I'll just see if I can get that. Sorry, my screens are. Oh, there we go. Does he say that? Is this? Yeah, this is. What does he say? So it even looks a bit like this is definitely it. Forgive me if I'm missing it. Did anyone else spot this? But I'm just looking for where the judge considered the point about okay, it would be really bad if you're homeless, but it's not going to be a severe prejudice to your ability to pursue the appeal. Because I'd have thought they could get away with that argument here. But actually, I don't think it's. Oh, yeah, sorry, look, here we are. Sorry. Down the bottom, it says counsel for the counsel for the council tried to rely on quadia, which I think was the case I mentioned a minute ago, where they said it was you didn't need a lawyer to get involved, and they relied on that. They said the appeals on the points of law, grounds and skeleton arguments, and evidence had all been prepared, so there was little to do. So they quoted that directly, and PB's barrister got round that or overcame that argument by referring to another unreported county court case, which is here, where they said that personal circumstances were capable of tipping the balance in the appellant's favour. So basically, I think what this case here of SN v Waltham Forest, I think the judge is saying, if your circumstances are so bad that you're going to have a really awful time on the street, I'm not going to apply the test of whether your lawyers can proceed with the appeal without your input. Because in theory, somebody could die and the appeal could go on. So I'm pleased to see that that was rejected. The thing you'd need to do, if anybody's trying to run these arguments, the point that the judge made about the applicant in PB was that her case, her conditions were exceptionally bad. So he's saying this is an exceptionally bad case. But I think that, when you're looking at a particular case up close, it's often possible to make that argument about many people. And that's not to trivialize it, but it's still possible to run it. And it's a really good foot in the door anyway. And it's nice to see a sensible decision. Does anyone want to discuss that before I go on to the very final point, which was another post that was one of the links Karen sent about a post from Alice Irving at Doughty Street about actually issuing a 204A appeal?
I mean, just to echo or kind of build on what you just said at the end there, Will. So, because when I first read this, the nearly legal summary of it all, it was kind of almost like disheartening in the sense that Struth, someone with all of these diagnoses is still kind of like on the cusp. But I think the fact that the judge kind of made a mandatory order to say, no, you need to house this person whilst the appeal happens, says to me that it's kind of like it's a little bit more reassuring, because it's kind of like I guess in a lot of cases the judge would kind of send them back and get it to kind of make the decision again. But if it's so bad that they're going to make this mandatory order and sort it out that way, then it does say that it's kind of well outside what would be considered reasonable. Does that make sense? And is that a fair kind of assessment of it?
Yeah, sorry, I'm just trying to get my screen back on, but it's still not going. No, I think it's a very positive decision, but it's a very sort of positive decision against a very negative background, if you see what I mean. Because the history of I wrote a blog post 10 years ago out of frustration at these awful decisions that were coming in. And I put the link to that on here. Sorry, it's more difficult for me to navigate now. Where is it? Is it here? No, not that one. I can get to it. I just go to W Flack blog. Yeah, there we go. Yeah, here we go. So I wrote this post, which I called, I think I mentioned it last week, or I was talking to somebody, because I'd forgotten I wrote this. And it was saying that, basically Section 204 appeal was no right of appeal at all. Because if you go all the way to appealing and then they say, yeah, you win, but actually you don't, what's the point? So that shows how negative everything was. And I was looking at the earlier cases there, and Mohammed. So over 10 years on, we've got a good decision there, and much respect to all those involved in getting it. If I just go back to the
I had
other, oh yeah, great, fire away.
yeah, I just it was, and perhaps it's a bit negative and flippant, so apologies, but it was when you were saying about the sort of charging it in the library. My first thought there was that's how many that's that could open doors, couldn't it, to a charity being like, we're being helpful and we're now going to charge people CPAP machines so they can sleep on the streets at night and get loads and loads of funding to do this actually, you know, and local authorities would love it. And it reminded me of, you know, like lots of pet charities that are like, oh, we'll take your dog. And then it means the person's just not housed their dogs, and charities that are trying to do good but absolutely like sort of ignoring the law side of things. And perhaps it's really unfair, and perhaps I'm being too cynical tonight, but when you said that sort of like library thing, I could just like a dystopian future where like you've got rough sleepers charging CPAP machines and all of this sort of life-saving equipment, perhaps, like, yeah.
It's true, it's a very bad precedent.
I think there was mention in there about, wasn't it, the person had been in a like emergency sort of like severe weather like kind of protocol thing or something.
Like a dystopian future where like you've got rough sleepers charging CPAP machines and all of this sort of life-saving.
Yeah. That was me, sorry.
That's right. I just thought. So I think that actually happened. I think that actually like the night show or whatever had actually been allowing it. So I think if there are any night show managers like watching this, then they just need to like refuse, and because in one sense, if you refuse to help that person because you think it's going to put them at risk, which it would do, then it's going to put it back on the council to actually sort it out. I think there's a lot of situations like that where actually, as Shanna says, you know, charities are kind of being either trying to be helpful, or they're just basically, you know, think that it's the only option, when actually just standing your ground with the council and saying no, over to you, is actually going to be far in that person's interest. Yeah, much more than it would be just to kind of try and help and sort of like, you know, bob along and kind of mess things up in the long run.
Yeah, I mean, if I could just, I know it's slightly off the point, but I was thinking to myself the other day as I was going for a walk around where I live, and I found a library which was a beautiful early 20th century library built in about 1910 or something, one of those sort of millionaire charity. Is it Carnegie that gave a lot of money for libraries in London? And it was a sign outside it saying this library was due to close down in 2016, but we, the local people, sort of got together and kept it open. And then there was lots of flyers for different sort of, you can probably guess the sort of social activity sort of that was going on in there. And I thought, yeah, the funny thing is what use can we find for libraries now? Because they obviously, the idea of going in there and getting an Agatha Christie novel or whatever people used to do in the 1940s has gone, hasn't it? And there was a time when they were sort of seen as places. Oh, am I wrong there, Shannon? You look like you disagree.
No, I think like perhaps for adults it is, but I think for kids, maybe it's just parents I'm aware of, but they certainly take their kids to the library to kill a few hours and to not spend loads of money on books that will get destroyed, sort of go to the library instead as a cheap day out. But again, maybe that's like a class thing as well. I think lots of people buy stuff now instead of like going to the library and borrow.
Do. Well, they listen to
but
audio
yeah, so
books.
I think maybe for families, it's maybe a bit of a bigger.
Yeah, and there is a thing of kids when I go to, because forgive me if I'm talking about libraries. You can say stop talking about libraries, please. But the my local library, the one nearest where I live, I actually go there on Saturday, the first Saturday of every month. This sounds showing my age and that, but there's a local history group that meets, and you sort of sit around a table in the library and look at old photos of. And you say, oh, look, there's the high street when it still had trams on it. And then maybe somebody very elderly will come along and say, yes, I can remember when the trams were there. So we'll listen to them talking about that. And I really enjoy that. But when I'm there, I notice quite a lot of kids. There's so much space in the library that the kids are able to use it as a sort of play area. So that's really good. But I was just thinking maybe in the future, maybe it would be good to keep libraries going. And I'm not saying one good way would be so that you can charge people's sleeping machines so that the council doesn't have to do it. But if councils put money into libraries and then they said, for instance, we'll keep them open till late at night and we will provide charging, we will help people. I mean, that's not a reason to say, and then you can go and sleep on the street with your machine, because it's not even clear whether the thing would charge. I think it probably needed a direct. Anyways, that's too technical. But yes, so that was. I'm digressing on libraries. I just like to see libraries continue to exist, but they're like sort of pubs. Well, pubs are a bit similar. They used to be a sort of community thing, admittedly that involved drinking alcohol and not particularly nice. I never particularly liked the atmosphere in pubs. You get dirty looks if you bring kids in. Now, that's all changed a bit, but I don't know. There could be things that people could benefit from, and homeless people too. But I digress. In that case, it was particularly stupid, I think, for them to talk about using. I've had that before. With, do you know when after HOTAC they came up with a definition of homelessness, which was slightly, I think it was HOTAC, where it wasn't about suffering harm. They came up with this version that you'd find it more difficult to cope with the effects of homelessness. And so that's a slightly, I mean, it's slightly less severe. But I was getting these decision letters that said you can get cheaply priced meals at Sainsbury's, which you don't need to, you can just open a sort of salad thing up and you don't need to cook. Because one of the things about being homeless is you can't prepare food. So they were coming up with all these ingenious ideas to show that you can, so it's related to you can charge your disability equipment in the library, and you can go to Sainsbury's where they do special meals, even though they're probably unaffordable. So that's that. So I will move on because we're getting time's going by. And I've actually got a comment. I've got two comments which I'll come on to. One, I should just say, if anybody, I mean, thank you for leaving comments, but as Mike always says quicker than I do on the beginning of the show, please don't say things about yourself and phrase questions in the first person, because then you're disclosing data, which if I show the thing up there, it's arguably I'm sort of releasing stuff about you. But I'll paraphrase it if that's okay. But just to go back to the very last point on my notes, this is really just for the lawyers or for the real sort of hardcore 204A followers. The issue here is the actual mechanics, the practicalities of issuing a Section 204A appeal. Because what we've been focusing on so far is how awful it is trying to get justice for the client or redress for the client when you've issued it. But the problem is, for the last 10 or 15 years, the county courts have been on their knees because the government cut their funding so much that they had to shut down all their counter areas. And so in the old days, if you had an urgent application, you would go to the window of the court and somebody would deal with it. Nowadays, you can do that, but you have to phone in and make an appointment to do it. And they'll normally only do it for about 2 or 3 different types of situations. One is where you're applying to suspend a warrant, the bailiffs are coming to evict you. And the other is where you need an injunction or, I don't know, to stop something. But this article here that Alice Irving wrote, it's a little bit old now, but it's still an interesting read. She wrote this one: how to get urgent interim relief in a Section 204A appeal. I think, well, I would repeat myself again by just adding, this isn't how to get relief, it's how to apply for relief and then fail to get it, if you see what I mean, because the system's so stacked against you. And Alice herself, after going through all the stuff, sadly concludes that there are few cases where a mandatory order is likely to be made, which is what you want, because if the judge isn't going to order them, as in PB, there's no point other than winning some sort of legal argument. So she talks about the problems they had in trying to actually issue one of these things. And they would call the court up and they'd say, oh no, computer says you can't issue because blah, blah, blah. And so they literally had to be onto the court and, persuading them. And eventually they got a judge to consider the urgent application. Because this is a situation where you've got a negative 202 decision and they say, no, we're upholding the decision that you're not vulnerable and we're going to cancel your B&B booking tomorrow and say you're out on the street in 3 days. So you've got to issue an appeal and then try and get a court order requiring the council to house them. And what Alice talks about here is the difficulty they had in just getting the paperwork into the court and processed. There are ways around that. I've had some painful experiences myself trying to get courts to issue 204A appeals. And I came up with what I thought was an ingenious solution to this, which was, why bother with the county court at all when you can go for a judicial review? And there was a case which was up here where they said, no, you can't go for a judicial review. But I thought if you could show that you'd had experiences of the kind referred to here and that the county court just wasn't, because I've had cases where I've been writing to the court and they're just not doing anything with the 204A appeal. And this goes on for two weeks or something. And so I was getting to the point where I was writing to the court saying, look, if you don't respond, I'm going to apply to the High Court for judicial review on the basis that there is no other redress available because the county court just isn't responding. But then Sarah Steinhardt, a barrister who listeners or viewers will be familiar with, and Mike, I think she's been a guest on at least one of your podcasts, hasn't she, Mike? But she came up with a really fantastic suggestion, which I hadn't thought of, which is that the High Court judges can have jurisdiction to sit as county court judges. This may sound all a bit silly, but it's apparent. I've never tried it in practice, but you may have noticed over the recent years there's been a change in county courts in that it used to be it was the Lambeth County Court. Well, actually, that closed about 10 years ago. But the Wandsworth County Court, the Bromley County Court, the whatever county court, Luton County Court. But now they're not called Luton County Court, Bromley County Court anymore. They're actually called the County Court at Bromley and the County Court at whatever. And the reason for that is not just style, it's a lot of substance there because there is only one county court now. And it has offices at different locations. And so it's a very centralized thing now. And the High Court judge, if you really needed an injunction badly, you could do what we used to do in the old days, and you could ring up the High Court and say to the judge's clerk there, they have a duty judge for emergencies, and that would be things like if somebody's being deported or somebody needs an urgent operation and they don't have capacity to consent to it, those sorts of things. You can get that judge on the phone at any time of day or night and then ask them, and you say to the judge, I'd like to ask you to do this sitting as a county court judge or with jurisdiction. Or if you're not prepared to do that, please do it as a High Court judge on the basis that county court's not functioning properly. You could be in danger of getting shouted at, but I think if they realise the gravity of the situation, if you said, oh, you were somebody, you had somebody in PB's case, for instance, situation, very serious medical condition on the street, county court not responding. Because if you ever try and ring the county court, you normally get through to a caller centre and they won't do anything other than read out what's on the screen, or they won't put you through to the court in question unless you have a hearing, which is like 1 day away or something. So it is really difficult to communicate with them. Maybe we'll talk about that in another show, just how bad the county courts are. I hasten to say, despite very hard work by the staff there, especially at Bromley County Court, where I'm really impressed, they do actually answer emails and things, which is often too much for people at other courts. Anything anyone else wants to say? I mean, thank you. I've been talking sort of non-stop. I hope I'm not talking over people. So I'll just talk about the comments. So if I go to, let me see. So I think I can. That is the old one from last time. So if I go to, here we go. Somebody's put out teach me to talk about libraries. It says libraries are full of fiction novels, nothing else. Well, maybe we could have a discuss. I'm going to resist the urge to discuss that, but I think I've said enough about libraries for tonight. But thanks for that comment. I have noticed actually the sad thing about society nowadays is that the true crime section is like the biggest section. It's the same in bookshops, and people seem to be obsessed with reading about crime. Really, I don't know what it is, but I used to. One of my hobbies was to go into the bookshop, my local bookshop, when Tony Blair's autobiography came out, was to move it from the autobiography section to the true crime section, but for his role in the foreign policy. But that's another story. So that, yes, enough about libraries. Sorry. Then, yes, thank you, Paul. You've rephrased this. Now I know that it's well. Anyway, so somebody's just got accepted for priority main housing due to CCAP's sleep apnea machine. Well, yeah, I think you should. I mean, but the problem is that this is, you often get questions on these Mike's and I's show that saying, if I've got this, will the local authority accept I'm in priority need, or will they house me? And the true answer is hopefully, but you never know. They might have a go at arguing ridiculously that you're not. I mean, I got one the other day, somebody who was HIV positive and on a lot of medication. 30 years ago, nobody would have dreamt to say that person wasn't vulnerable. But now it's sort of fairly standard to just say, oh, no, there's nothing to see here, move on. Not a serious condition. So I could see sleep apnea. Sorry,
That's the
Karen.
question. Do you see it diluted in the more common the illness is, the more they deem it less of a priority then?
The more
So
common illnesses.
yeah. So when, like you said, with HIV, the more common it became, the more.
Yeah, I mean,
they were
for
like, oh,
those
it's
old
standard
enough to
now.
remember when HIV appeared on the scene back in the second half of the 80s, it was a bit like coronavirus in the sense that it was killing a lot of people. But also there was a sort of sense of, oh my God, what are we going to do? We have to, it's a very serious medical condition. And so there was lots of, dedicated social services teams and I think actually it's true to say that the medication, that the development of full-blown AIDS from HIV or isn't necessarily as inevitable as it was in the 80s. And forgive me, that's probably a hideously ignorant thing to say. But nevertheless, I would have thought that HIV should be treated as something to put you in priority need. But to answer your question, I just think it depends on the council. If you get some crazy, I don't know, if somebody doesn't like the applicant and they really want to go out of their way to deny them something, they'll say, well, yeah, whatever you've got is, and they can, no, I'm going to give in to the temptation to mention now medical, but you can usually get them to sort of reel off something about how the person needs a sleep apnea machine, but other than that, there's no particular, they haven't been referred to emergency services because of respiratory problems, so I don't see a problem. No particular housing need. So I don't know. I mean, I'm glad to hear that some councils are being sensible, and I think that is all of. There's this one here. Does anyone understand this? Anyone speak? I think this is this Latin or is this somebody just having a? This is from the same person that said libraries are full of novels. We've got Jus in Rem Persona. So I'm afraid I don't. My Latin isn't good enough to answer that. So if you wanted to translate it, you've got about another 2 minutes. But I think other than that, if everybody's, unless anybody else has got anything to say or
Going to
ask,
add
or...
Harris's point really quickly.
Mm-hmm.
I think that happens as well when housing officers see more and more perhaps complex needs, and people are labelled as complex and various things, that they do sort of move that invisible goalpost that doesn't and legally shouldn't exist. But I think they do move it. It's one of the things around like PIP assessments. Loads and loads of people with lived experience want mental health professionals assessing PIP applications, and I'm like the odd one out because I think that's a really bad idea, because I'd rather have a physio assess it, because they have to be objective, because they don't have an understanding of mental health, so they have to take each case as its own merit. Whereas
Very good point.
a psychologist or a psychiatrist who perhaps has just seen someone with, I don't know, paranoid schizophrenia, who's really quite severe, not on medication or whatever, then see someone with PTSD and they go, what are you complaining about? And I think there is that comparison that happens with housing officers similarly.
Totally, yeah, I agree. I've had that with consultant psychiatrists. When you ask some of them for a report, they've become sort of battle hardened by their day job, and if they're on the wards with people who are like being sectioned, you know, and are in a really bad way, they tend to think, what's all the fuss about, when it's somebody with depression who can't open the post. But I guess that on the other hand, they may hopefully take an informed view of their job. And I've been to some good webinars by psychiatrists from Expert in Mind about things like ADHD and post-traumatic stress disorder, which show a high degree of sympathy for or compassion for the subject. Speaking of which, would anybody be interested in next time? What was I going to talk about? Talking about mental capacity and the law, because I've been doing some research into the role of the official solicitor, which you may or may not know much about, and the slight sort of unreality of how mentally ill people are supposed to engage with the legal system, and the civil legal system, that is. Unfortunately, the criminal legal system results in many mentally ill people living in prison rather than getting treatment. But that's another story. But I was thinking I could talk about that next time. Is that interesting? It applies to homelessness too, because if you're seriously meant, you know, it's like, well, I won't. So spoiler alert for the next time. But you know, it's that problem I find when if I'm out and about and I'm seeing people begging in the street, and I think, well, this person is vulnerable and would probably get housed. And I'm tempted to go up and say, why don't you apply to local authority? And here's my card, I'll help you. I mean, I happen to be too busy. Plus, I don't think it's particularly good for me to be doing that. It's a bit like touting for work. But you think, well, the problem is just them engaging, because if they're you know, if it's a major effort to engage with the authorities, they probably just, it's easy to get ignored. But I'll come back to that another time. So are we on for Thursday? Yeah. So if that's okay, I'll say goodnight for now then to everybody, and thank you for watching, and thank you all very much for joining in and listening. It's just been listening to me, my monologue for most of it, but I hope that was interesting. And I'll see you tomorrow, Karis. Yeah, we'll have a chat in the morning, and see you guys on Thursday. Bye.
See you later.